He's a bully.
The professor, known as the Dean of Canadian Political Science, says there's a reason governments have so rarely used the Notwithstanding clause. Peter Russell says the Charter's creators put the clause in never anticipating a leader like Doug Ford.
It really was designed for an age when our leaders were liberal Democrats who respected the rule of law. Here we have a man who does not respect the rule of law.
But Ford accuses judges of not respecting the laws of the elected legislature.
He's the judge. I'm the premier. He gets to use his tools. I'll use every single tool to stand up for the people of Ontario.
It's a position promoted by populist leaders around the world and embraced by their supporters.
And frankly, from a political perspective, I think Premier Ford is quite happy to have the fancy people and the unelected judges against him and the people with him.
Some of the people against his plan were left stunned by his latest move.
That he'd be willing to use this again if the courts got in his way. And that is frightening. The Constitution and particularly the Charter protect the rights of individuals.
One city councillor running for re-election appealed to the progressive conservative legislators.
Please, you need to be able to recognize that not only are you torching the brand of your party, but you are going to go down in the history books for doing all the wrong things, for infringing on people's constitutional rights.
Toronto's mayor asked why Ford is turning to such drastic measures.
This invocation of the Notwithstanding clause is a mistake. It is an overreach. It is using a sledgehammer on a fly. And in terms of the size of the issue involved here.
The mayor says he will meet with the city's lawyers, but acknowledges once the sledgehammer has fallen, there's nothing the courts can do.
Thank you very much.
Ron Charles, CBC News, Toronto.
Let's take a closer look now at the Notwithstanding clause, where it came from, and why governments were given this power. Here's the brief.
I'll use every single tool to stand up for the people of Ontario.
One of those tools, the Notwithstanding clause, Section 33 of the Charter of Rights and Freedoms. It allows federal and provincial governments to pass laws overriding the Charter. So even if those laws contravene basic individual rights, the court can't overturn them. So why is it there? Well, when the Charter was being drafted, it was a last-minute compromise to get the Western premiers to sign on. They were worried judges would overrule the popular will.
If ever the judiciary goes berserk, there's always that clause, that's a plug, you pull the plug.
Provinces are allowed to use it with a vote in the legislature, but it is pretty rare. It's only been invoked about a dozen times in history, for example, to override a court ruling about French language rights in Quebec. And Saskatchewan used it to protect back-to-work legislation.
It is unlikely ever to be used except in non-controversial circumstances.
Jean Chrétien was the Justice Minister, playing a major role in negotiating the clause. He doubted governments would use it much because
it will be politically very difficult for a government without very good reason to introduce a measure.
It's always been viewed as a kind of last resort because research has shown that Canadians generally support the Charter. And overriding it to push through laws was considered to be politically risky. Well, to help put this into perspective, let's turn now to Carissima Mathen, a constitutional law expert at the University of Ottawa. Your reaction, first of all, to what Premier Ford has promised to do?
Well, I wasn't as surprised by the idea that he would invoke the Notwithstanding clause, although it is a really big move for the government of Ontario to do this. It's never done it before in the entire history of the Charter. I was, though, surprised by, frankly, what seemed to be a fairly cavalier attitude he has towards the Constitution and the way he kept emphasizing his legitimacy versus appointed judges as though there's some kind of contest, and in any kind of contest he should automatically win. I mean, that's just not consistent with the way that we understand the rule of law.
And not only is he vowing to invoke the Notwithstanding clause in this case, but he says he'd be comfortable doing it again. Let's listen to another excerpt from what he said earlier today.
I also want to make it clear that we're prepared to use Section 33 again in the future. We're taking a stand. If you want to make new laws in Ontario or in Canada, you first must seek a mandate from the people.
You know, for a generation, I think we've been taught and told that premiers and prime ministers would be very reluctant to use the notwithstanding clause because it's just such a big step and there'd be a political cost to that. But when you hear the premier of the biggest province in the country speaking so comfortably about invoking this, does that worry you that it might have an influence on other leaders across the country?
The notwithstanding clause is, you know, it's a tool, it exists in the Constitution, but it has been treated for 35 years as an extraordinary act, not a routine act, not a casual act. And the worry is that could lead people to view the notwithstanding clause as something that we should regularly be invoking. And we have to remember that this is about our Constitution. It's about the fundamental tenets of our society. And we need to be really careful to adopt a dismissive attitude, or the idea that the Constitution somehow doesn't really matter as long as you have an electoral mandate to do things.
We have just a few seconds, but let me just ask you this. I mean, one of the reasons that he says he's using it in this case is that this was a bad decision by the judge. His constitutional experts tell him that. What's your sense of this decision in the city council seats?
I think there are some weaker aspects to the decision. Normally, the way that you settle that is you go through an appeal process, and you, in fact, have a higher court weigh in. So while, again, he's within his authority to do this, the Constitution gives him that authority. I think the language and the ideas he's invoking are really the bigger story here.
Kirsten Mamathan, thank you very much.
You're welcome.